Good afternoon. My name is Tony Pitts. I am the principal here at Law Office of Tony A. Pitts, located in Round Rock, Texas. And I've been a civil litigation and probate attorney for the past 15 years, and I practice primarily in Williamson, Travis, and the surrounding counties. I'm going to speak to you today about consumer protection at the behest of Texas Legal. Texas Legal is a statewide nonprofit legal plan which provides its members with affordable legal help. As a member of Texas Legal, you can protect yourself and your family from the burden of high legal costs. Their plans include coverage for estate planning, family law, DUIs, and much more. To learn more about Texas Legal and view their plan options, please click the link to their webpage, which can be found in the description of this webinar. The first topic we'll cover is red flags when hiring contractors. Then we'll talk about your rights when entering into personally solicited contracts. Then we'll talk about the Texas Deceptive Trade Practices Act, or DTPA for short. And finally, I will say a word about Texas lemon law. At the conclusion of my presentation, I will try to answer at least a few of the questions that those watching live may have. I do want to note before proceeding that in my practice, I represent both consumers and contractors, and it is my hope that everyone listening can benefit from this presentation, regardless of which of those you are. I'm also going to cover these topics in broad strokes, as they could really be each their own webinar. So I'll cover them broadly, but if you do have specific questions, I'll try to address some of those at the end. All right, now to jump right in, red flags when hiring contractors. Now, when you have individuals that you are contracting with to provide work or services in your home, there are certain things that you want to look out for and that you want to know in dealing with these individuals or corporations or companies. The first is you want to make sure that you have that your contractor hasn't given you insufficient contact information. You need to know who you're doing business with. If all you have is the first name and cell phone number of the person that you're dealing with, then you are not going to be protected if things go south with that contractor. You're going to want to know their full name. You're going to want to know the name of the owner of the business if it's not them. You'll want the full business address. You'll also want the phone number for the owner if you don't already have it from your contact person. And you want to know the business name. Now, one thing to note is that a lot of contractors do business under assumed names. That includes corporations, some companies and smaller companies, they do business under assumed names. So Johnny's Roofing might not be the legal name for the actual business. It might be something different, ABC LLC or something like that. But you'll want to know and want to ask if it's not provided to you in the information that you get from the contact person that you're dealing with, what the actual name of the business is. So that, if things go south, you'll know who you need to sue. And like I say, the information that you need to have is the address that you will have to serve this business at. If you do have a situation where it comes down to a matter of litigation. And for businesses, they typically are required to have a registered agent to accept service and process, and you'll want to be able to look them up and find out where they are. Now, you may have a question about, well, how do you find the registered agent for a business? There are ways that you can go about doing that just by searching online. The Texas Comptroller maintains a website where you can find taxing entities, and you can look up any business that's required to be registered with the state there. And they will typically list whether it's an active business and the address and name of the registered agent that you would need to serve with process. You can also do that search through the Secretary of State's website, but it does cost and there's a fee associated. To do it through the Comptroller's website is no cost. All right, so next red flag is they don't check out. The information that you get from them, once you do receive their contact information, is not current. the business information isn't current, that they don't actually uh, they aren't actually situated at the address that you've been given, or you do the comptroller search for the name, and the comptroller shows that their franchise tax is ended because their charter's been revoked or they're not an active business in the state of Texas. Uh, you can also look up in the county clerk's records. The county clerks for Travis and Williamson County both maintain websites where you can do judicial searches through their records. And if you search for your contractor and you see a lot of lawsuits pop up against this contractor, that would be a red flag that you probably don't want to hire this individual or business. And so typically, I would encourage you to do some due diligence and to make sure that you have been given accurate information with respect to the business and that they check out. All right. Next red flag is insufficient contract for the job to be performed. Now, if you've contracted for something like a home renovation where you're going to spend $80,000, and the contract that you have from your contractor to bind all this work and this obligation is a one-page agreement, then that should send up some serious red flags. It generally, especially if it's a homestead, there are disclosures, there are protections that need to be in the contract, both for you and for the contractor. You cannot summarize all that would need to be said in one page. I've, believe it or not, had clients of mine who've come to me and they've had $50,000 contracts with a contractor, and it's really just the estimate that they were given with a vague description of the work to be done. That is not going to be a contract that will protect you or the contractor in those situations. For one, you are really just trusting that somebody you're giving a very significant amount of money to is going to do all that they say, even though they may not be bound to do it in any particular period of time. And for the contractor on that side, you are not protecting yourself to have lien rights against the homeowner if your agreement is only a one-page estimate. So one more thing I'll say about estimates is that when you receive an estimate from a contractor, you should not have to sign it. I have seen it be the case in my years of practice here where an estimate is given for work and the homeowner is asked to sign the estimate as evidence that they've received it or whatever. They're told it's non-binding, but then when they sign it, it's actually a contract. And you want to be careful of that. You should not have to sign an estimate that you're given for work to be done. If you do sign it, more likely than not, it contains some contractual language in there that you may not want to be bound to if you choose not to go with that particular contractor. So make sure that you don't sign estimates that are actually contracts. And as my next point says, a job over 10K on a one-page contract should be of concern. Now, a renovation project on a homestead that will use subcontractors, there should be some pages associated with that agreement. Those kind of contracts can be recorded in the property records to create a lien obligation but if your contractor that you're dealing with is, again, handing you a 1 or 2 page agreement for something that significant, then more likely than not, they don't have experience in that area that they're contracting with you for. And whether or not they actually complete the job to your satisfaction is up in the air. I would strongly encourage you not to enter into those kind of agreements. And especially for my last point here, vague or incomplete descriptions of the work to be done. That contract that you have, that written agreement, like we say in the legal world, if you don't have it in writing, then it doesn't exist. So if the work that you have contracted for doesn't appear in the written document that you have, where it appears where it's very vague, then you are not protected if that work that you anticipate to be done isn't done, and you have to litigate. Excuse me, you have to litigate over that. So make sure your contract is beefy enough to protect both parties, and that it isn't just a naked estimate. Now, I will qualify and say that for some jobs that are just one-day jobs, where the contractor is going to come in, do something for one day and leave, you don't really need a super significant contract if it's just like replacing water heater or something like that. But if you are doing a renovation project, then there should be some more meat on the bones of that contract. All right, next point. Now, when you're dealing with homestead property here in Texas, we have our homestead property has homestead rights associated with it. And if you do a contract on a homestead as a contractor, you have to make sure that all owners on the property are parties to the contract. And if the contract is using subcontracted labor or materials, owners, you have a retainage obligation at law. By law, you are required to retain at least 10% of the contract amount for 30 days after the work is completed to cover subcontractors who may have claims that they weren't paid for the work that they provided. So if the contract that you are entering into requires that you pay all amounts in full in advance of the completion of the contract, or as soon as the contract is completed, then that is not what your obligation at law is, and you should not do that. You have the right to retain that 10% so that you can cover claims that may come after the work is completed, and you do that for at least 30 days. There are disclosures that are required by law that should be part of the contract. I've seen many contracts for people who have done work on homesteads, but they don't have the required disclosures. I will say that not having the required disclosures isn't a death knell for your claim, but the law does say that you should have these disclosures be part of your contract. So you will want to make sure that the required disclosures are in there. And if you have questions about what those disclosures are, you can look under Texas Property Code Section 53. That's what deals with lien rights with respect to this type of property. The disclosures are in there. And if you need assistance in reading those, then I would suggest you consult an attorney. Because if you don't comply with what the lien rights are statutory. You have to strictly comply with them, or you don't have lien rights. That applies to original contractors and subcontractors. And yes, subcontractors do have rights to lien property when they're not paid if they have an outstanding claim against the property for the work. Excuse me. All right, next red flag, sketchy payment requests. So if you have a contractor who's asking for payment in cash and they're not giving you a receipt, that is a red flag, because now you have no record, no proof that you've given them the money that you've given them if they haven't given you a receipt for it. And generally, you want to not pay people in cash if you can avoid it. Sometimes, for smaller projects and things like that, you can get away with doing cash deals. But for the most part, if you're doing major projects or anything, I would say in excess of $10,000, you want to make sure that you're getting receipts, or you're making payments via check, or ways that you'll be able to show later if things go south and you have to do a litigation. If your contractor asks for too much of a down payment, that's a red flag. So if you have a project that's going to take a matter of weeks to complete and your contractor wants half down, I would strongly advise you not to do that, because you give that much down, and more likely than not, you won't see your contractor for a while, if at all. If you give too much down, if they're going to be at your project for a number of weeks, then you should have a payment schedule established where they receive 10 to 20% at certain stages throughout the project. But to ask for half down when the project is going to take weeks or even months is way too much of a down payment. Now, again, if the contractor is only going to be there for a day, and it's just a 1 day job or something like that, and they ask for half down, I would say that's not entirely unreasonable, just because they want to make sure that you're going to pay too uh, when they dedicate the time. But you definitely do not pay in full before the work is done, which is that last bullet point. Uh, the the payment for the work is the incentive that the contractor has to complete your job. And you definitely do not want to give all that incentive away before the job is actually complete, because then you may not get it completed. There is a doctrine out there called the doctrine of substantial completion, which basically says that if a contract has completed, I believe the percentage is about at least 85% of the job, then they can be entitled to the compensation due under the contract. And I think uh, it's written that way because we have, of course, some consumers who don't want to pay until they're completely and fully satisfied, which they may never be. The law provides some grace for contractors, for consumers who might be overly obsessed with their satisfaction with the job when the job has been substantially completed. All right. Untruthfulness, another red flag. So if you contract with someone and there is a payment schedule in the agreement and they're not honoring the payment schedule, they're asking you for advances or monies outside of that payment schedule, that will be a red flag to you. You should not pay your payments to the contractor should not exceed the work that's being done. And I've had many clients come to me who were on payment schedules with their contractor. The contractor started wanting more, giving all kinds of excuses as to why they wanted more. The payments got ahead of the work, and unsurprisingly, the work didn't get done, or got done, but not in a good workmanlike way. So be careful about paying outside of the payment schedule. Even if you get a good reason, there's always a good reason given, but stick to the payment schedule if that's going to be it, so that you make sure that if things go south with the contractor, then you're not out that much money when you have to go and hire someone else to finish what they started. If your contractor doesn't start a job when they say they're going to start it, that might be another red flag. It might be overcommitted, and everything that you were told about your job might not come to fruition. So if you're still at the beginning, then you can tell your contractor, "Hey, you didn't start when you're supposed to start. Let's go ahead and let me go with someone else who's not so busy." Or if they don't progress the job as they represented. A lot of times you'll see a contractor, at least I've seen in my practice, a contractor start a job, do initial demo or something like that, and then the client or mine or the homeowner doesn't hear from them for a long time and starts being concerned that they're not coming back to finish. So if you get to that point, then you again don't want to be overextended on your payments to the contract, and you want to be able to go out and hire someone else to do the work if they're not going to do it. But before you terminate a contract like that, you may want to just call a lawyer up and see if you can get a consultation on how to move forward. All right. Now, for contracts that are entered into with solicitors, and again, these are I'm going to focus on the people who come to your home and offer you goods or services. They may offer you pest control or solar panels or security systems, things like that. Texas Business and Commerce Code Section 601 deals with your cancellation rights with respect to these types of transactions. And I just want to put this information out there because I get this question a lot from people who call me and they'll ask, well, I thought you could cancel any contract in Texas within 3 days. Well, that's not necessarily true. Um, you can cancel certain contracts with 3 days notice, and these are the types when you're personally solicited um, at a place other than the merchant's place of business. So you might be solicited by people at the grocery store, at Walmart, or you might be solicited at home. But when you're solicited in places other than the merchant's place of business, then it can fall under 601. And then you agree to purchase. Your agreement to purchase is given at a place other than the merchant's place of business. Um, Meaning if you agree at the store, hey, I'll go ahead and do that. I'll sign me up. Or if you do that at home, hey, go ahead and sign me up. And your agreement to purchase a good or service exceeds $25, and agreement to purchase land exceeds $100. I haven't seen this happen at all with land generally, because that's not how we sell land around here mostly. So I'll just focus on, like I said, the personal solicitations for goods and services at home. There are some exceptions, and I did put those in here. And again, this doesn't apply to like your online purchasing and stuff like that, because you're not being personally solicited and those things. You're not having a merchant send a representative or anything to you. You're just shopping online, so this doesn't apply to that. But there are some exceptions, which are listed there. Now, generally, with respect to these types of contracts, you have a 3-day right to cancel. So if someone comes to your home, they sell you a security system, they install it, you do have a right to decide in 3 business days, that's not 3 calendar days, but 3 business days, that you don't want it, that you'd like them to come back and get it. You have every right to do that. The merchant has to give you notice of your right to cancel. They can't not tell you that. They have to tell you orally and in writing that you have the right to cancel. And they have to give you a completed cancellation form. Now, that's one thing even a lot of the merchants don't know, that they have to give you a completed cancellation form, because I've seen that be the case. But it has to be completed with the name and address of the merchant. It has to basically inform you of your right to cancel, and it has to be easily detachable from the contract and include legal disclosure statements. Basically, the legal disclosure statement is that you have the right to cancel this agreement within 3 business days. As you can see on the next slide. Importantly, the cancellation notice has to be in the same language that as that principally used in the oral sales presentation. So if the presentation was given to a Spanish speaker, the cancellation notice has to be in Spanish, and vice versa. If it's given to an English speaker, it has to be in English, and whatever other language, Vietnamese or Telugu, whatever language the presentation is given in, the cancellation notice has to be in that language. Has to contain the date of transaction, name and address of the merchant, and the disclosure statement saying that you have the right to cancel by midnight of the 3rd business day. All right. After the notice of cancellation is given, if you do opt to cancel, as the consumer, you have to be prepared to return the goods to the merchant if they have complied with the law and given you the proper disclosures. They have at least 20 days to reclaim their property. You have no obligation to deliver the property to them. So if they say, well, go ahead and stick it in the mail and send it back to us, you don't have an obligation to do that. If they say, go ahead and ship it to us, UPS or something like that, you don't have an obligation to do that. They have to come back to your home to pick it up. And if they don't do that, then you're permitted to keep that unclaimed property without the obligation to pay for it. So for the merchants to know, and for you to know, if you give them cancellation notice and they've installed something or given you something or kept something at your home, they don't come back to get it within that 20 days, then you can keep it. All right, so a few important points. The failure to give notice of cancellation renders the transaction void. And again, notice has to be given orally and in writing. And if the merchant doesn't do that, the transaction is void. And of course, it's more voidable because it's really up to you. But if you decide, hey, I don't want this, and they never told you about your right to cancel, the transaction can be rendered void. The merchant can't make you waive your right of cancellation. They can't put in the agreement that you waive the right or that you don't have your 3 days. That is a void clause in the contract, so they can't make you waive it. And they're not entitled to any compensation for a properly canceled transaction. So if they say, well, we did come out there and we spent time, putting this in, so we're just going to deduct something from the monies that you paid or that you agreed to pay, or we'll bill you for. No, they're not entitled to anything at that point. So a lot of times you'll find that the folks who are coming to solicit, they won't just do one-offs or something like that, because they know that if you cancel after that, then you're not obligated to pay them for anything. And they do have 10 business days to refund your money. And again, that's business, not calendar days. Business days means it doesn't include weekends or legal holidays. All right. And you can sue merchants who are in violation. So if you have actual damages, meaning one thing I didn't say is that a lot of times the solicitors will come through and they will have you enter into an agreement. If it's a finance portion to that, then they will assign that financing to a finance company. They're not allowed to do that before 5 business days after the transaction. But if they do that and you end up with a finance company to deal with, and you have any kind of damages, or if they've installed something, and but if you have any damages that are suffered, you do have a right to sue them for violation, and you can recover attorney's fees and court costs as part of that suit. Of course, any lawsuit is going to be a cost-benefit analysis. Whether the cost, if it's going to cost you a lot more to pay an attorney to go after your claim, then you may want to try to bring your claim in small claims court or something like that. Now, Texas Business and Commerce Code Section 601 is a tying statute to the DTPA. The Texas Deceptive Trade Practices Act. I'm really going to hit this one with broad strokes, just because there's so much to cover with the DTPA that it really can have its own hour-long webinar. And I just want to hit the broad strokes to basically tell you how it applies to you. It is our consumer protection statute in Texas. It applies to sale or lease of goods and services, and goods is defined to include real property, such as a house or condo. And so you can find this in a real property situation, mostly not when you have new constructions, when you are having a home built for you. Those kind of claims will fall more so under the Residential Construction Liability Act, which is Chapter 27, I believe, of the Texas Property Code. The DTPA you would find under Texas Business and Commerce Code Section 17. It starts at 17.41 and goes from there. But this is more so applied to resales mostly, and you don't have to be a merchant in order to be liable under the DTPA. A person is very broadly defined to basically include whatever entity, and so if you purchased a home from someone and they didn't tell you or didn't disclose certain things about the home, that they should have, that could be a DTPA claim. But the DTPA generally prohibits false, misleading, or deceptive acts in the conduct of trade or commerce. And so it basically prevents fraud and business dealings that involve trade and commerce. There's a laundry list of things that are considered deceptive trade practices at law. That's found over section 17.46 of the Texas Business and Commerce Code. There are about 34 things named. It's a non-exclusive list, so it doesn't list everything that you could claim as a deceptive trade practice, but the three biggest ones that I see most often, or that I bring claims for most often, are representing that goods or services have characteristics, uses, or benefits that they don't have, representing goods and services or a particular standard of quality if they're another, and failing to disclose information about a good or service with the intent to induce the consumer into a transaction into which they would not have entered had the information be disclosed. Now, the benefits of the DTPA, because as I said, it's pretty much fraud, but you don't get, in a standard fraud claim, you don't get attorney's fees. In order to recover any kind of extra damages, you have to kind of prove malice and things like that. But under the DTPA, you can recover your economic damages. You can also recover mental anguish damages. You can recover your attorney's fees and your court costs, and you can recover treble damages if you prove a knowing or intentional violation. Basically, if you prove that someone knowingly or intentionally defrauded you, then you can recover treble damages, and that would be up to 3 times the amount of your economic and mental anguish damages. But you should note that the DTPA encourages settlement. And so in order to bring a claim under the DTPA, you have to give a 60-day pre-suit notice. There are some exceptions as to when that notice isn't required if you're running up against limitations or something like that. But generally, you're going to have to give a 60-day pre-suit notice, and the person that you're pursuing the claim against has the right of inspection. Most of the time, I see DTPA claims, or I deal with them in vehicle situations. When someone has purchased a vehicle from someone else, and that person may not have told them everything there was to know about the vehicle that they knew was wrong, and now the purchaser is finding out things that should have been disclosed. And a lot of times I hear from that client, well, I don't want to give them the vehicle. I don't want to take it to them because I don't trust them. Well, they do have the right of inspection. If you want to pursue your DTPA claim, you're going to have to give them the opportunity to look at it and confirm that what you say is wrong with it is wrong with it. Even if you're contending that they already knew about it. So they do have that right of inspection. The DTPA it then provides that they can make you a settlement offer. It has to be a 2-component offer. It has to compensate you for the damages that you can say that you've incurred, and it has to compensate you for your legal fees up to that point. And you are required to consider a good faith settlement offer. And if you don't consider the offer, or if you say that, no, I just want every little penny that they owe, and you reject an offer, and then you proceed with your claim, and you ultimately get substantially the same or even less than you initially had your claim for, from the judge, or if it's tried by jury. Basically, if you get the same or about the similar or even less than what you asked for, then your recovery can be capped by the amount of the settlement. You basically get the lesser amount of the settlement offer or whatever you have proven. All right. Okay. So like I said, I was going to hit the DTPA in broad strokes. There really is a lot there. You want to, if you do have a claim or a question about the DTPA, you'll want to contact an attorney. If you need a pre-suit notice letter, I would definitely recommend that you have an attorney write it, because there is case law out there that says that DTPA notice letters, pre-suit notice letters were insufficient and didn't trigger the DTPA because they didn't contain all the elements that they were supposed to. And that's probably more often than not found when people try to write them themselves. So I would definitely have a lawyer do that for you if you want to pursue a DTPA claim. Now, a little bit about the lemon law. I don't really need to talk that much about the lemon law because the Texas lemon law is, and let me go to the next slide here. It's administered by the Texas Department of Motor Vehicles. They have a website already set up with lemon law claims. I get these calls, but really this is information that's just out there. Their website is very thorough in terms of what constitutes a lemon law claim and how to go about the complaint process to bring a claim. This is something that you can definitely do yourself without the assistance of an attorney. So the thing to note specifically about the lemon law is that it applies to new vehicles and used vehicles still under the original manufacturer's warranty. And that's really the sticking point, that it's under the manufacturer's warranty. The original manufacturer's warranty does not apply to extended warranty. So if you got an extended warranty on the vehicle and it's a used vehicle, may not be covered under the lemon law. But for used vehicles that are still under the original manufacturer's warranty, it does. And it requires multiple failed attempts by the dealer to correct the issue. So for serious hazards, I think the dealer gets 2 opportunities to correct the issue. For other maybe non-serious claims, they get up to 4 times to correct the issue. But you do have to keep giving them that opportunity to correct it. And if they're not able to do that, then at that point you would have a lemon law claim. And you don't need an attorney to follow the complaint process. So as I said, the website that the DMV has, here's the link to it, txdmv.gov/motorist/consumer-protection/lemon-law. That's the website to go to, and pretty much all the information you need about the Texas lemon law can be found there. All right. Now, I've quoted some of the law that I've relied on for this presentation, but here it is. Again, if you want to go and look at this stuff yourself, there's a lot I did not cover that's in this law, because that would be a much, much longer presentation. But just to give you some broad information and some hopefully helpful information on the things that we did talk about. I see that there aren't any questions, and so I will thank you all for watching today. Hopefully you got some good information. And again, if you have questions, more specific on more specific topics or things that you may personally be experiencing and you'd like some direction, you're definitely free to reach out to me. My office website is there and my telephone number is there. The best way to reach out to me, though, is through email, which you can find on my website. So thank you very much for watching, and have a great day.